Okay, I'm going to get started. Greetings, everyone. My name is Rachel Hasna, and I'm with the University of New Mexico's Division for Community Behavioral Health. Welcome to our Law and Mental Health didactic series. Excuse me. Just a couple of announcements about our CEU process. We will submit a link in the chat. If you just toggle your mouse at the bottom of your screen, there's a chat icon. You click that and that'll bring up your chat box. In the chat box will be a link. Copy and paste it, click on it. It'll send you to an evaluation. Fill out that evaluation and a certificate of completion is automatically generated for you. It's your responsibility to save a copy. So if you're on your smartphone, you'll want to take a screenshot. If you're on your laptop or your computer, you save it as a Word doc or a PDF. You can also email yourself a copy. Scroll down to the bottom right is where you're able to email yourself a copy. Make sure you put your email in correctly, otherwise you won't receive the email. Folks have also been asking about last week's lecture. We did not record. The lecturer requested that we not record, so we do not have that recording available. He did say that he would share slides, so I'm still waiting on those, and I don't yet have those. So if folks haven't received, that's why. Today we are recording and we will have slides to share towards the end of the week. I will get that to everybody who's registered for today's lecture. And I think that's all I have, so I'll hand it over to you, Julie.
Thank you, Rachel. Welcome everyone to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're so glad to have you all here joining us today. My name is Julie Bravko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. First thing I want to do is remind you to join us next week. At that time, we have Randy Salikin, who's going to be presenting Conduct Disorder, Advancing Our Understanding by Using Specifiers. Next, for our talk today, just as always, please ask your questions in the Q&A anytime you feel comfortable, but just know we're probably not going to get to them until the end. We will try to get to as many of your questions as possible. Please forgive us if we can't get to yours. For those of you that want the CEUs but are on a tight schedule, just know you have to stay for that full hour, but you don't have to stay longer than that. I'll try to let you know when that hour has passed, but we will likely be staying on longer to address questions. So now it's time for what we've all been waiting for. I'd like to introduce to you our speaker for today, Attorney Karen Newirth. Attorney Newirth works for the Exoneration Project and civil rights law firm. She's a nationally recognized expert on the law and sciences of eyewitness identification and a co-author of the textbook Eyewitness Testimony, Civil and Criminal. She writes, teaches, consults, and comments on issues relating to wrongful conviction and police-generated evidence, including eyewitness and confession evidence. She's trained thousands of attorneys nationwide, including through the National Forensic College. And from 2013 to 2019, she was an adjunct professor of law at Cardozo Law School. Ms. Newirth has spent her career representing the criminally accused. Prior to joining her law firm, she was a senior staff attorney and founding member of the Innocence Project Strategic Litigation Unit, where she used litigation to reform the law relating to eyewitness and confession evidence. Before that, she spent 8 years as a criminal defense lawyer in private practice, where she represented individuals and entities in all phases of criminal investigations and prosecutions in state and federal court. She's a 2002 graduate of New York University School of Law, and prior to becoming a lawyer, she taught high school in Brooklyn, New York, and San Jose, Costa Rica. She graduated from Brown University with a concentration in educational studies. Ms. Newirth, we're so grateful for your time and expertise. On behalf of the University of New Mexico, I'd like to welcome you and thank you for presenting today. I'm now going to turn it over to you.
Great, thank you so much. It's really nice to be here. So I'm going to spend the next hour kind of, unfortunately, racing a little bit through the law and science as it pertains to eyewitness identification evidence, and particularly through the lens of wrongful convictions. My objectives for today are first that participants understand the role of eyewitness errors in causing wrongful convictions, understand that there now exists generally accepted, scientifically supported best police practices for eliciting eyewitness identification evidence, and then finally have an understanding of the legal framework for evaluating eyewitness identification evidence. So eyewitness misidentification is the leading contributing cause of wrongful convictions that have been established by DNA, factoring in nearly 70% of those cases. The number is somewhat lower when we talk about non-DNA wrongful convictions that have been established through other means, and that can generally be explained by the types of cases that involve DNA versus those that don't. So eyewitness misidentification is a leading contributor to wrongful convictions for such crimes as murder and sexual assault and other sexual crimes. Why is eyewitness misidentification so common in these wrongful conviction cases? First, as you all well know, human memory can be unreliable. Second, making an identification, particularly of a stranger, and I put an asterisk there because it is also true about people who are known to us. We have a number of examples in the wrongful conviction cases where witnesses made an erroneous identification of someone they knew, and often that is someone who was only known casually to them, which sort of exposes memory to a greater array of possibility of errors. But making an identification of another person can be a difficult task. Traditional police procedures have tended to undermine the reliability and accuracy of identifications, and the existing legal framework has generally failed to ensure that eyewitness evidence that comes in is reliable. So what is the basis of our knowledge with respect to eyewitness identification and criminal cases? One is just the general foundational research about human memory and perception. And of course, that's hundreds of years of study, peer-reviewed and generally accepted information about how memory and perception work. And then over the last 40 years, we have a robust subset of applied social science, specifically looking at eyewitness identification. And that includes laboratory studies, archival studies of criminal cases involving eyewitnesses, studies of DNA exoneration, so cases where we know because DNA has shown us that witnesses were wrong, and then a smaller number of field studies, so studies in the field where eyewitness researchers have been able to go in and study actual eyewitnesses in real criminal cases. So those are the four types of applied social science research in the area of eyewitness identification. And this research has resulted in 2 APA white papers, the first published in 1998, the second in 2019. And then we now have kind of emerging neuroscience research, which is starting to supplement these areas of more robust research. So the key relevant findings from the general study of memory and perception are that the ability of people to perceive the world around them, their environment, is limited, and interpretation bias and expectations play a significant role in filling in the blanks, what we're not able to perceive. That memory and attention are efficient processes and therefore selective, but that means that they also don't function like a video recording and can function inefficiently under certain circumstances, which are often associated with observing a crime. That memory functions as a three-stage process: encoding, storage, and retrieval, where interference, loss, and errors, including contamination from external sources, can occur at each stage. And finally, that memory deteriorates over time. Within the applied eyewitness identification research, key findings include the trace evidence analogy and lineup as a memory test, the distinction between system and estimator variables, the role of contamination and what happens during suggestive identification procedures, the confidence accuracy relationship and confidence inflation, the limitations of witness descriptions, and the failure of the legal framework and system to accommodate these research findings. And I'm going to spend some time now discussing each of these key findings. So the trace evidence analogy basically says that eyewitness memory should be treated as trace physical evidence, such that there should be standard protocols for collection of that evidence that can be reported so that fact finders can understand exactly how that trace evidence was came to exist, how it's been treated, what the chain of custody has been, etc. And so that we understand that contrary to perhaps common sense or what people have historically believed, that eyewitness evidence is not some form of robust evidence that cannot be altered, but to the contrary is much more like a piece of trace physical evidence, which is subject to and at risk for contamination, deterioration, and the like. Second is the notion that a lineup is a memory test. And that is that the lineup should be designed to give investigators more information than they had before the identification procedure, that it should be built in such a way as to ensure that it is a recognition task as opposed to a reasoning task. Meaning that we don't want witnesses looking at a group of pictures and comparing them to one another and finding the best answer. What we want to do is figure out if a witness has a strong enough memory such that when they look at a photograph, they can say, yes, that is the person, I recognize them, and to know that they recognize them from their observation of a crime. And that those witnesses who don't have a strong enough memory to make that recognition are discounted or eliminated. So as a result, the objectives for law enforcement are that they construct a true memory test, that in dealing with witnesses, they avoid any contamination of the witness's memory, and that they preserve the witness's actual memory for later use in a criminal trial. Estimator variables have been identified by eyewitness identification researchers as those variables that inhere in the witness or the perpetrator. So they're outside of the control of the system, but they can affect and do have an effect on the strength of a memory. These include age and race. With respect to age, people at kind of the outer ends of the lifeline do less well at making memories of people's faces. And also people tend to do better at identifying people within their own age group. And likewise, the findings on race have consistently shown that people are less accurate at making cross-racial identifications than they are at making same-race identifications. High levels of stress tend to be bad for memory formation. People do well with moderate levels of stress, but the high levels of stress that are generally associated with witnessing a crime result in less good memory formation. Distance is probably one of the few absolute factors. So research has shown that after about 250 feet, the human eye, the naked eye, cannot accurately identify a stranger's face. But there has been robust research that can replicate just what individuals can see at particular distances and under different lighting conditions. Duration of the observation, the longer a period of time a person has to make an observation, the better the memory, the strength of the memory will be. The weapon focus effect is that when a visible weapon is present, witnesses tend to focus on that as opposed to the other information, including the face of the perpetrator. Retention interval, memory starts to fade quickly after an event and sort of drops off precipitously in the hours and days after an event. Attention is important. Is a person paying attention to an individual, the other individual, or are they paying attention to other information? We see that with weapon focus, but also often you have a witness who is unaware that they're observing the perpetrator of a crime. For example, somebody leaves a store while a robber walks in. They don't know that that person is going to be robbing the store, and so they were unlikely to have been paying careful attention. Lighting, as I previously mentioned, intoxication and other physiological conditions, including sleeplessness, for example, other drugs, narcotics, or prescription drugs can affect memory. And finally, the use of a disguise. Research has shown that disguises as limited as a hat or glasses, sunglasses, can reduce accuracy and the ability to form a good memory. And then researchers have also established the role of system variables, and these, of course, are within the control of the system and so have to do with the procedures that law enforcement use to conduct identification procedures. So first, the number and type of identification procedures. It is common in criminal cases for witnesses to be shown multiple identification procedures, but research has shown that this is a dangerous practice because it risks contaminating a witness's memory with multiple viewings of the same police suspect, and can do things like increase a witness's certainty or commitment to their identification. Type of administrator, this should be there should be clear who the suspect is, lest they bias the witness or leak information. Witnesses should receive pre-procedure instructions, which tell them essentially not to assume that the actual perpetrator is contained within the identification procedure, that the investigation will continue whether or not they make an identification, because witnesses naturally assume that if they're being presented with an identification procedure, the police must have caught the suspect. The lineup should be fairly composed. There should be only one suspect, which should who should not stand out vis-a-vis the known innocent fillers. Witnesses should not be provided with any feedback such as good job or other extraneous information like, yes, that's what that's the person another witness chose, or when we arrested him, he had the proceeds from the crime, or anything like that. And procedures should be recorded so that there is an objective record of what happened. So many people sort of will say, well, are there any circumstances when an identification can be reliable? And the answer is absolutely, and we know this. But first, the conditions surrounding the original event need to be conducive to the formation of a strong and accurate memory. The memory has to be carefully preserved and not contaminated, and the witness's memory must be properly tested. So with all of this, the scientifically supported best practices for conducting identification procedures are these. First is that the police should have a good basis for including a suspect in the procedure. So historically, there have been quite a few identification procedures which have been used and have result in innocent people being identified simply because they were included in a procedure. So for example, historically, law enforcement would collect physical mug books of people who had been arrested. And then they, if they had no leads, they would just have a witness sit down and start flipping through mug books. There was no reason to think that anybody who was in those books was had committed the instant offense, but witnesses were nevertheless left with those photographs and able to just, look and look and look. And so there was no good basis and no way to test whether or not, if they identified someone, they actually were right or wrong. That has now been modernized, and many police departments have electronic mug book searching, which present the same dangers. Likewise, you have also historically and currently something known as a show up in the street, where a crime will occur and a description will be given, and then someone will be stopped near to the crime, generally fitting that description. That can also be dangerous because the witness again is inclined to believe, oh, this person must have done it. They're primed to make a positive identification, and police have not constructed a test where they would know, oh, is this person just a guesser likely to choose? Are they going to reject a known innocent person? Second, that all identification procedures be conducted by a blind administrator, obvious. Third, that witnesses be given instructions prior to the procedure in line with what I just shared with you, that lineups be composed in a fair manner. Research is still ongoing about what is the best way to compose a lineup, a live lineup, or a photo array. Should the match be to the witness's description, the suspect's appearance, some combination? But in all respects, the suspect should never stand out from the other fillers. Immediate confidence statements should be recorded from the witness. So how certain were you in your identification? Again, some dispute in the research or in the application of the research about what kind of language should be used for those confidence statements, but some statement by the witness of his or her confidence in the identification should be recorded, and then the procedure should be recorded. Failure to do any of these things can increase the witness's rate of choosing, which is obviously a problem for innocent suspects. That can increase the likelihood that they choose a suspect, which is a problem because we're not then, operating strictly from the witness's independent recollection, but they're responding to some stimuli inherent in the identification procedure, and it can increase the witness's certainty. Practices that ought to be avoided include the use of composites, multiple procedures, and exposing the witness to extraneous information. So we know that memories can be easily contaminated, and we see this in the wrongful conviction cases where 32% of the eyewitness misidentification cases established by DNA involve multiple eyewitnesses misidentifying the same innocent person. Now, a small number of these cases, of course, can be attributed to the fact that the suspect bore some resemblance to the actual perpetrator, but more likely than not, it's the result of one eyewitness being contaminated either by things that they were told by law enforcement or things that they were told by other witnesses or information learned from the media and the like. So eyewitness memories can become contaminated by statements and questions by third parties, including police and co-witnesses, media reports, the use of multiple identification procedures, memory source confusion. So I mentioned earlier the problem of witnesses who are somewhat known, or rather suspects who are somewhat known to a witness. People can be confused by someone that they're somewhat familiar with from the neighborhood or the store, and then erroneously think that they know them from the crime. And then witnesses' memories can get contaminated through attempts to make sense of what happened. So witnesses, especially now through the internet, social media, and the like, often become sort of amateur sleuths trying to figure out what happened, and then in doing so can contaminate their own memory. So I want to walk you through sort of a very famous, somewhat early study called the post-identification feedback paradigm, which describes powerfully the ways in which memory contamination or feedback specifically can alter witnesses' memory for both the actual event and also for their experience of the identification procedure. So in this study, participants were shown a video of a crime. They were then asked to do make an identification through a traditional identification procedure. Feedback was manipulated. So the experimental group was told, good, you identified the suspect, and the control group was given no feedback. And then the researchers took measures of both the witnessed event and the lineup identification procedure. And so participants were asked, how certain were you at the time of your identification that you identified the real gunman? How good was the view you had of the gunman? How closely were you paying attention? How well could you make out the details of the gunman's face? How easy was it for you to identify the gunman? And how good of a basis did you think you had for making an identification? So you can see that these questions are sort of a mix of asking participants about their observations of the event and also their experience of the identification procedure. And so the control group showed, basically very few people in the control group had a positive high extreme answer. So most of them, only 10 or 12%, were very certain of their identification. Less than 5% across the board would say that they had a very good view, that they were able to observe the details of the gunman's face, that the identification was easy for them to make, or that they felt they had a very good basis for their identification. But when you simply told the participants, good, you identified the suspect, you see that their experience of both the event and about their identification changed dramatically. More than 45% would say that they were very certain of their identification, more than 25% that they had a good view, just around 18% that they could see the details of the face, more than 35% found it easy now, and 32% said that they had a good basis for their identification. So we see that just a simple feedback, good job, really alters people's memory for the event dramatically and also their experience of the identification procedure. And what is probably the most problematic here is this manufacturing of false certainty among witnesses who have been given some form of feedback. And so subsequent research has focused on what other behaviors can alter witness memory and perception in these ways. So pre-identification feedback, meaning when a witness is called and told, we got the guy, researchers see similar inflation. The use of suggestive lineups. So when the suspect stands out from the fillers, you see similar inflations. Biased lineup instructions. I want you to choose the guy, so implying that the person is in the lineup as opposed to those prophylactic instructions that I described. We see similar inflation. And then non-blind administration, so using an administrator who knows who the police suspect is will result in similar inflation. And so the question of certainty is quite important. And so what we know about certainty is that under pristine circumstances, meaning the best practices that I have described to you earlier, certainty does have a good relationship with accuracy. Pristine meaning one suspect per lineup, the suspect doesn't stand out, the witness has been given prophylactic pre-lineup instructions, blind administration was used, and the witness's confidence statement was recorded immediately, then we can see a good relationship between confidence or certainty and accuracy. However, where circumstances are not pristine, meaning in the real world, confidence has a statistically weak correlation with accuracy. We also know that confidence is highly malleable and inflated in the ways that we just discussed, that witnesses themselves will not recognize when their confidence changes. So we have information from witnesses who testify in trial, and they testify at trial that they're 100% confident in their identifications. But when you look back at the original police recordings, they're actually equivocal in their identification. Confidence is the most powerful single determinant of whether or not observers of an eyewitness's testimony will believe that they are accurate. So that's judges, jurors, police officers, and others will tend to believe witnesses who express high levels of confidence. And then finally, we know that confidence is conveyed through nonverbal cues, which makes it very difficult to counteract in a trial setting. So for example, defense lawyers may ask that the witness not be permitted to testify about their confidence. And even if that request is granted, which it often isn't, jurors will still be able to identify a confident witness and will believe that they are more likely to be accurate. Some other kind of features of the applied research or findings of the applied research, eyewitness descriptions tend to be quite poor. Witnesses generally will only describe about 5 to 7 items, half of which will be clothing. Hairstyle and color are often given. Details of facial features are rarely mentioned. Unusual features are often volunteered, and pressing for additional detail will increase guessing while reducing a witness's accuracy. And there are a number of explanations for these features of eyewitness descriptions. One is that people tend to process faces holistically, and so generally do not focus on individual features. And even if they have focused on individual features, often lack the language to describe them. Research has shown that the ability to describe a face is often separate and distinct from the ability to recognize a face, and therefore a person might be quite good at making a description and quite bad at making an identification, or the reverse. And then also, for all of the reasons that we discussed, the factors that can limit a witness's ability to make a good memory recording of what they've observed. And so we see that all of these problems really can come together in the use of composite sketches. And so this is a slide that is showing a photograph that was shown to a number of study participants, and then the different composites that were created by those study participants using standard identikit police software for generating composites. And so we can see that the composites, each of these composites really varies wildly from the other composites, and also are not very close to representing the person in the photograph. And so again, we have a problem similar to the use of month books and show-ups, where there is no real basis for inclusion of a suspect in a procedure, which is now this composite sketch goes out into the world, and citizens who are trying to be helpful will say, oh, that looks like my neighbor Bob. And now Bob gets picked up, and if he doesn't have an alibi, or he doesn't remember where he was, or he's inaccurate in describing where he was at the time of the crime, he gets sort of caught up in this system that is sort of designed to push him towards indictment, trial, and conviction. So this is sort of that, as I said, was a very kind of quick overview of what research has shown, what the applied social science in the area of eyewitness identification has shown, and what the foundational memory research has shown. And I'm happy to take any questions on that material before I turn to the legal framework and some of the issues in court with this identification evidence. Or I can continue. Julie, you want to?
Okay. You can continue.
Okay, thank you.
Yeah.
So the US Supreme Court in 1977 set forth a decision which until very recently had been used by every state to govern the admissibility of eyewitness identification evidence. And it's sort of probably the best example of, you know, the collision between law and science, because although the research that I just described to you did not yet exist at the time that the Manson decision was set down, the court somehow managed to create a legal framework that has now been shown to be totally at odds with all of the social science research. So the court said, you know, when identification evidence is challenged by a defendant, first, reliability is the linchpin in determining whether or not that evidence is admissible. And the way to determine whether or not the evidence should be admitted is to ask first, were the procedures impermissibly suggestive? If so, you balance the effects of suggestion against certain reliability factors. And the court enumerated 5, though the court did say these were non-exclusive, but courts applying the Manson test have generally applied these as the 5 exclusive factors to consider. So first, the opportunity to view. Second, the degree of attention. Third, the witness's certainty or confidence. Fourth, the accuracy of the description. Accuracy, of course, is in quotation marks because, you know, if we presume that the police suspect is not necessarily the perpetrator, it's very difficult to know whether or not the description was in fact an accurate description of the perpetrator, or if instead it actually just matches the suspect. And then the time between the crime and confrontation. And the court said that eyewitness evidence will be suppressed, in other words, will not be admitted in evidence, only if there's a very substantial likelihood of irreparable misidentification. More recently, the Supreme Court clarified, again, I believe erroneously when you consider what research shows, that this test only applies to to identification procedures that were intentionally orchestrated by law enforcement. So if, for example, a private actor engaged in a very suggestive identification procedure, eliciting an identification, it would not be subject to this due process analysis. So what's wrong with the Manson balancing test? First is that it fails to entirely consider the quality of the witness's memory. The test asks, were the identification procedures unduly suggestive, without recognizing that the amount of suggestion that might be required to alter a witness's memory is going to be directly related to the quality of that memory, right? So if taking the picture of this meal on the left, right, if the person is somebody who we ate dinner with, who we lived with, who we had the opportunity to view under good lighting conditions and low levels of stress over years and years and years, it would require a tremendous amount of police suggestion to alter a memory, if it could be done at all. On the other hand, and the picture on the right is showing, kind of a more common view that a witness to a crime might have, somebody viewed from the back or a weird angle, wearing a mask and poor lighting. Well, that witness, we know, would likely not have created a very strong memory, and therefore would be more likely to be affected by suggestion, right? Have their memory pushed around or affected. Next is, the balancing test says, okay, did suggestion occur on the one hand? And if yes, then we're going to balance it against these reliability factors. But that study that I just walked you through shows us that you can't balance suggestion and reliability. Suggestion infects these reliability factors, once suggestion has occurred, people's memories are for both the event and for their experience of doing the identification procedure have been irreparably altered, and there is no way to bring them back to their virgin state.
Hey, Karen, can you hear me?
I'll try calling her on her cell phone.
Hey, Karen, can you hear us? Hey, Karen, can you hear us? Hi, all. Thanks for your messages. We're having some connectivity issues, so just trying to figure it out, y'all. Thanks.
Sorry, everybody. I think that's better.
Yeah.
Am I back?
Yes.
Sorry about that.
That's okay. It
All
happens.
right.
You might need to share your
Yeah.
screen again, though.
Okay. Am I back?
Yes, but I don't see your PowerPoint.
Okay. I'm having trouble with the Zoom. Can you see it?
Yes.
Good?
Yes.
Okay. My apologies, everybody. So the second problem with the Manson balancing test is that it ignores suggestion from non-state actors. As I mentioned, witnesses are often subject to extraneous information, whether it's from the media, from social media, print media, from friends, family, doing their own research, and that can also likewise contaminate their memories for events and alter both their confidence, their memories of the event, and their experience of the identification procedure. The third problem is that these are largely self-reported factors, which are of course subjective and can be unreliable. We're counting on witnesses to accurately report their opportunity to view, yet we know that people generally will do a very poor job at estimating things like the duration of events or distance or the attention that they paid. We've talked about certainty, and likewise we have seen that witnesses will adopt features into their descriptions. They start out with those kind of bare bones descriptions, 5 to 7 features, and then over time, as they're shown photographs or they learn information from police, prosecutors, or other witnesses, they incorporate that into their descriptions and make them much more elaborate. And this is not to suggest that witnesses are doing that intentionally, but rather that this is just a natural progression in the process. Next problem is that some of these reliability factors are not well correlated with accuracy. A witness's self-report about their opportunity to view is not necessarily a good measure of accuracy, nor is their degree of attention. They may report that they were paying a very careful attention because of what was happening, and yet if a gun was present, they may have been focusing entirely on the gun. Certainty we've talked about, same with description. And courts have tended to largely ignore the research findings on the valid factors. I mentioned the time between the crime and confrontation. Then we know that there are a number of good indicators, factors that would tell us whether or not an identification is likely to be reliable, and these are generally ignored by courts. Those include estimator variables, right? If we had a good accounting from a witness of all of those factors that may have been at play when they were observing the event, that might tell us from kind of an ex ante perspective, is this person likely to do a good job? Did they make a prior non-identification or a less than certain identification? This would tell us something about their memory. Recent research has shown that people who make, under pristine circumstances, who make very strong positive identifications at a very fast rate of speed are more likely to be accurate. Some courts have incorporated some of this research. As early as 1991, the Utah Supreme Court did include some of this research and has since updated their the Utah State Court's evaluation of identification research in ways that are more faithful to what scientific research shows. And then finally, we see that there are practical problems. Courts are reluctant to suppress identifications because the natural result of that in many cases, if the case turns on eyewitness identification, will be to effectively end the case before it gets to the jury, right? The Manson test sets up an admit or suppress dichotomy, but doesn't really give courts a lot of intermediate remedies. And then we also see that courts don't actually make very good records of what they're doing in applying this test. They often don't fully appreciate the degree of suggestion that might be present. They may minimize the degree of suggestion. When they look at an identification procedure, they might say, well, it looks fair to me, without ever actually evaluating whether or not a procedure is in fact suggestive or if it's fair. If there are any reliability factors, courts tend to assess those independently, ignoring the corrupting effects of suggestion. They often don't consider other reliability factors, and then they tend to look to other corroborations, other corroborating evidence, corroborating in quotation marks, even though A, they're specifically forbidden to do that under Manson, and B, research on known wrongful convictions has shown that many wrongful convictions involve multiple types of erroneous evidence, and that's particularly true among the eyewitness cases, that eyewitness misidentification evidence is often accompanied by false confessions or bad forensic evidence or other types of erroneous evidence. Then finally, and this is not necessarily a problem with Manson, but it's a problem within the judicial treatment of eyewitness identification evidence, is that jurors have many misconceptions about eyewitness perception and memory. It's certainly getting better over, say, the last decade, as I think a lot more information and particularly popular media about wrongful convictions has made its way into common knowledge. But jurors still have many misconceptions about eyewitness perception and memory. Jurors tend to believe eyewitnesses even when they're discredited. They're believed more than other witnesses, often more than scientific evidence. The confidence problem that I've mentioned, and then cross-examination tends to be very ineffective with at getting to the truth, because eyewitnesses believe they're telling the truth, and so they sort of are consistent in their telling. Their confidence outweighs, contradictory testimony, and jurors are inclined to believe them. And then we're still dealing with this problem of in-court identifications, which some state courts have begun to limit, recognizing that they really don't have any probative value, because they're basically suggestive identification procedures that are occurring right in front of the jury, but they're incredibly persuasive, as Justice Brennan recognized back in 1981.
Hey, Karen, if you can hear us again, you're cutting out.
Karen, can you hear us?
Since we're within 9 minutes of the end, why don't we post the link for the people?
I'm going to go ahead and try to give Ms. Newirth a call. If we're not able to fix this, we'll go ahead and end for today, and we'll see you all next week. We sincerely apologize for all of these technical problems. But I'll see if maybe we can have her call in and even finish via telephone. So just hang tight. Thanks, everybody.
And if folks want to look at the chat, we have added the evaluation link in the chat.
I think I'm back. I'm very sorry for this.
No problem.
Can you
So
hear me?
we can. There's a bit of a delay, and I'm wondering, Karen, I can share my screen and go through the slides. You would just let me know when to advance.
I think I'm really at the, pardon?
Continue.
I think I'm really at the end. What I can say that there is some reason for optimism. We have seen many police agencies around the country have adopted some version of the scientifically supported best practices. Some state courts, including in Massachusetts, Connecticut, New York, Hawaii, Alaska, Maine, and a couple of others, but really those are the big movers, have been incorporating scientific research to alter their version of the Manson balancing test, the state law versions in those states of the Manson balancing test, addressing non-state actor suggestion, limiting in-court identifications, creating robust scientifically supported jury instructions, and just, you know, generally treating eyewitness identification as the risky form of evidence that we now know it to be. And that, you know, one of the things, you know, one of the great problems that's illustrated in this area is the conflict between the legal system and scientific research. Scientific research is, you know, founded upon the act of questioning and never leaving knowledge as fixed, whereas the judicial system is founded on the principle of precedent and fixed laws and rules that never change. And so, you know, the process of incorporating science into the law is one that is necessarily slow. But I think that as it progresses, and what we have seen in the eyewitness identification category is that courts have, you know, looked to decisions by one and another in sister jurisdictions in order to more quickly change precedent than we see in other categories of evidence. So my apologies again. I have a child at home doing Zoom school, which eats up a lot of our bandwidth, and I appreciate your patience.
Thank you. Are you, we've got a couple of minutes for questions. Is that okay?
Yes.
Okay, perfect. So the first one is,
I can see them. I'm happy to go through them,
okay.
Julie, if that's helpful.
Perfect,
So
go for it.
pristine procedures, no, they're, you know, really, as I described and as that particular study described them, are not necessarily being used in any jurisdiction. There are, you know, many individual law enforcement agencies are using what would approach pristine conditions, but I personally am not aware of any identification procedure that really meets all of the criteria in a lab. That said, I think that there are cases, there's, you know, a handful of jurisdictions where you might have, this was really for the confidence accuracy relationship, where you might be able to show some relationship between confidence and accuracy. One of the big problems with confidence and accuracy is that researchers conducting studies on this have tended to use numerical scales for asking participants about their levels of certainty. Prosecutors have resisted this, of course, because that would sort of give defense lawyers the opportunity to argue to a jury that anything less than 100% certainty constitutes reasonable doubt. And so in practice, certainty statements are usually just, you know, witnesses are asked to say in their own words. So they're not even providing a very good measure to sort of say, well, how accurate do we think this is? Next question. Yes, witnesses may have their own mnemonic strategies to recall specific data. How do you ascertain their personal prejudices? Sure, it's personal prejudice. It's, you know, on an end, we're talking, of course,
Hey, Karen, I think the connectivity again has gone out a bit. No problem, Karen, we understand. Karen sent a message through the chat to the panelists that she's apologizing, but everybody, I think we understand with everybody at home these days that the bandwidth is maxed out.
Yeah, I think we can go ahead and end the formal presentation for today. We'll stay on for just a few minutes longer so that everybody can fill out the CU link. And then we will see you all next week. We sincerely apologize for the technical difficulties today, and hope you all have a good day. I think anything else, Rachel?
No, someone made a comment in the Q&A about rescheduling Karen, which, you know, as long as she's able to do that, but yeah, we'd love to have her back and apologize for the technical issues. It's hard when folks are home and everybody's working from the same net, so.
Absolutely. Yeah, and thank you all out there too for being so understanding.
Yes.
Okay.
If anybody needs the CEU link, if you're joining by phone or you are having issues getting to that link, you can always just send me an email, and I will also forward Karen the Q&A, the list of questions that came through the Q&A, and see if she's able to respond to some of these questions. Thanks, everybody. See you next week. Thanks, Kara. Have a great day.